So the Sixth Circuit and Ninth Circuits have held that there is the courts do not have the discretion to afford the inmate the opportunity to amend the complaint. And then the Fifth Circuit has held that the inmates can be afforded that opportunity, and indeed must generally be afforded that opportunity to amend the complaint. Now, again, this is a question of great practical import. As many of you have probably observed, prisoners do not typically draft their complaints, shall we say, artfully. I used to work for a clerk for a federal district judge, and the brunt of my work involved the processing of prisoner claims. And again, very often, you will see inmates sue parties who are not suable. They'll sue the state. Very often, there will be something, let's say with a medical claim, it looks like it could be that the prisoner could prove the facts demonstrating deliberate indifference. But right now, on the face of the complaint, it looks like this is now more a claim of negligence. Or maybe the prisoner hasn't included facts showing personal involvement of that particular defendant in the alleged constitutional provision. Again, this happens with a great deal of frequency, and very often I've watched a number of different district courts in different districts in the country, and very often the response has been to give the prisoner a chance to amend the complaint, depending on what the complaint actually looks like. And again, the question is, can you still do that? And the courts are divided on that question.
I don't understand the Ninth Circuit to have said you must dismiss the complaint. I thought it said you must dismiss the claim.
Okay, I'm sorry.
And
yes.
that's a very,
and you are correct. And
that's
you are
a major
absolutely
difference.
You are absolutely correct that on that claim, they do not have the opportunity to amend the claim. I'm sorry, I misspoke. The inmate does not have the opportunity to amend that claim. Correct. Any questions about the screening requirement of the PLRA? Okay, well then let's move on to the next hurdle that inmates must cross over, and that is known as the physical injury requirement. 42 U.S.C. section 1997 EE says that no federal action may be brought by a prisoner who's confined in a correctional facility for mental or emotional injury suffered while in custody unless there is a prior showing of physical injury. So the inmate cannot sue for mental or emotional injury without that prior showing of physical injury. Now let me give you an example of a case where this physical injury requirement would apply. It's a real case where the correctional officer held a loaded gun in the prisoner's mouth for a period of time and didn't shoot the prisoner, and so the prisoner sued, claiming that that had constituted cruel and unusual punishment. He didn't suffer any physical injury. He was suing for the traumatic experience, and the physical injury requirement would foreclose that kind of claim. At least that would be the argument. The threshold question concerning the physical injury requirement is this requirement constitutional? And thus far we have the D.C. Court of Appeals and the Seventh Circuit holding that the provision is constitutional. Seventh Circuit emphasized that it was holding that the provision was constitutional as applied in that particular case. And let me tell you about that particular case that came before the Seventh Circuit. It was the Zahner case. Inmates sued, claiming that they had been exposed to asbestos when working in the prison kitchen. So they were suing. They wanted an injunction, and they also wanted damages for their emotional and mental injuries as they waited for years to find out whether or not they were going to get terminally ill from this exposure. They wanted to be compensated for that. And one of the questions before the Seventh Circuit was, does this physical injury requirement unconstitutionally restrict the remedies available, or the remedial relief that a court can award for a constitutional violation? The Seventh Circuit did say that there is a point where the restriction of remedial relief is tantamount to taking away of the rights themselves. But the court said that when we reach that point, there would be a constitutional problem with the statute in question. But the Seventh Circuit said in this particular case, we hadn't reached that point. The inmates could still obtain an injunction to preclude their further exposure to the asbestos. And if they ever did get ill from the exposure to asbestos, they could recover damages for that illness. The Seventh Circuit acknowledged that the inmates would not be fully compensated for the injuries they suffered, for the years of wondering if they were going to die from the asbestos exposure. But the court basically reminded us and said that there are a lot of times when people do suffer harm, but they are not fully, and even from a constitutional violation, but are not compensated for that harm. And we know that because of application of immunity doctrines. One of the most significant questions raised by this physical injury requirement is what is the effect of this provision on constitutional violations that do not result in a physical injury? For example, violation of religious freedom. If an inmate was not permitted to have a Bible in his cell and he is suing for damages, is he foreclosed from bringing suit because there is no physical injury involved? Courts are divided on this question, and the Ninth Circuit and several of the district courts have held that the physical injury requirement does not bar suit in this particular situation. What they've said is this. They've said, well, the inmate who wasn't permitted to have access to a Bible is not really suing for emotional injury. He's suing to vindicate a constitutional right. And that's really the major part of their analysis. And the only, I guess, question, that would be raised by that is that not always true when an inmate is filing suit to seek redress for violation of a constitutional right, that they are seeking vindication of the constitutional right? So the result may be right of those courts, but it seems like there might be something more. It may or may not be right, but it would seem that there would be something more in the analysis. So we have some courts holding the physical injury requirement does not apply to that claim of abridgment of religious freedom. We have other courts, some district courts, concluding that it does apply and that the inmate can only seek an injunction so we can get access to that Bible in the future, or could seek nominal damages, but not compensatory. Now, the Seventh Circuit and a district court in the Southern District of New York have added a bit of a twist to this issue, and I've got the citation for the district court opinion here. Let me talk, though, about the Seventh Circuit case, because it's quite interesting in light of the other Seventh Circuit case we talked about involving asbestos exposure. In this particular case, Robinson versus Page, the prisoners were suing because there was, allegedly there was lead in the water. And so they were seeking damages because of their exposure to the lead in the water. The Seventh Circuit emphasized that this physical injury requirement only applies when the inmate is seeking compensation for emotional or mental injuries. And the Seventh Circuit said in this case, in that case before the court, that's not what the prisoner was seeking compensation for. He was seeking compensation for the physical effects of exposure to lead that cumulatively over time can have dramatically adverse effects on the prisoner's health. And this district court in New York had the same kind of analysis dealing with asbestos exposure, but in this particular case the inmates were suing not for emotional injury. They were suing because there's been this effect in their bodies. It may not manifest itself for a number of years, but they could bring suit despite this physical injury requirement. Question is, does the physical injury requirement apply when prisoners are seeking injunctive relief or declaratory relief? And thus far, the courts that have addressed this issue have said no, that it does not. The 5th, 7th, 10th, and D.C. circuits. Does the physical injury requirement apply to prisoners who have now been released? And they're seeking, in other words, can they seek compensation for emotional and mental injuries not accompanied by a physical injury? The Seventh Circuit has concluded that the physical injury requirement does not apply to released prisoners, and they've done so largely because of the way in which the definition of prisoners in the PLRA, or this part of the PLRA, prisoner refers to persons incarcerated or detained in any facility and who is accused of, et cetera, of a crime or adjudicated delinquent for violations of criminal law, et cetera. So again, the Seventh Circuit is saying that physical injury requirement does not apply to released prisoners. Now, what that means, if that holding is correct, what that means as a practical matter is this. If a prisoner, let's say the prisoner who had a loaded gun stuck in his mouth, if he is released before the statute of limitations elapses, he can recover damages for that violation, assuming it's cruel and unusual punishment. Whereas a prisoner who was the victim of the same kind of conduct who is incarcerated and not released before the statute of limitations has run would not be able to recover damages. There's some questions about what is the physical injury that would support a claim for emotional or mental injuries. What does that mean? What exactly is a physical injury? Now, something to note. Go back to the 3 strikes provision, and you will recall that there is that proviso in the 3 strikes provision that says the inmate with 3 strikes can sue in forma pauperis if he faces an imminent threat of serious physical injury. There is a seriousness component to that proviso or exception. Here, when we're getting into the physical injury requirement, there is not that reference to a serious physical injury. It just says that there has to be physical injury. What does that mean? Well, in the district, in the D.C. circuit, the court has said that somatic manifestations of emotional distress. An inmate says he's losing weight, he can't sleep because of all these bad things that have happened to him. Does that satisfy the physical injury requirement? That particular court is saying no. In the Northern District of Texas, the court said that the following did not satisfy the physical injury requirement: a bleeding tongue, injured shoulder, minor abrasions on the arm and chest, contusions with slight swelling of the jaw, wrists that were red and swollen, and scratches to the face and nose. And there are a number of other cases listed in the outline interpreting that physical injury requirement. Now, do you have any questions or comments about the physical injury requirement?
You know, there is an argument in the earliest days of the Republic. The court said it didn't matter because it never applied to anybody in the old days, but that the Constitution was self-enforcing. We got 1983, so that eliminated any question about the self-enforcing character of the Constitution. Because, as we know, once Congress speaks, that ends the federal common law. But where the Congress has now deprived the prisoner of a right to bring an action under the Constitution, as an example, because religious freedom doesn't result in somatic change, I suppose we're now going to revive the question about whether the Constitution is self-enforcing.
Right, right. There's a real fundamental question raised by the physical injury requirement. And again, the Seventh Circuit did intimate that there would be a point, or could be a point, where the restriction of remedies does, and seems to be actually suggesting there is that it is self-enforcing. But in that particular case, they said the restriction did not go that far.
There are lots of ancient cases that said that.
Right, right. And certainly Bivens is based on that principle.
Bivens is based on that.
Right, absolutely. Now, this is, in my opinion, and I've spent, I can't say even hours, it seems like a lifetime looking at these cases. I think this is tough stuff. I think it's very complicated stuff. And I think that I'm an educated person. Now, the question is, can prisoners understand all of these issues and complexities that we have been talking about? In 1994, there was a study by the National Center for Education Statistics. It's a very sophisticated study. Found that 7 out of every 10 prisoners operate at the lowest literacy levels, that they cannot understand complex written materials. They certainly can't integrate them. Now, the next question is, what happens if an inmate is so lucky as to cross over these hurdles and then crosses over all the other hurdles that people encounter when litigating a claim, and the inmate actually wins? Well, the PLRA not only erects some obstacles for prisoners bringing suits, but it also does limit the remedial relief that can be awarded prisoners. And there are two main types of restrictions. One is in the area of prospective relief. Let's talk about injunctions. At the time the PLRA was enacted, states across the country had court orders in effect governing conditions in correctional facilities in states. Over 30 of the states had prisons operating under court order, and then the Virgin Islands, Puerto Rico, etc. And there is in the PLRA a provision that says that if there is a court order granting prospective relief in effect, and there had been no finding by the court that the prospective relief was necessary to correct a violation of a federal right, and that it was narrowly drawn, and that it was the least intrusive means of correcting that violation. If there had not been that court finding, then the prospective relief should be set aside. Now, there is a caveat or an exception to that termination provision, and that is that if the court now makes written findings that the prospective relief is still necessary to remedy a violation of the federal right, it is no broader than necessary to correct the violation, is narrowly drawn, and is the least intrusive means of correcting that violation, then the prospective relief will remain in effect. One of the questions about the termination provision is, well, what does this mean as a practical matter? And that kind of depends on what the termination provision means by it. It says, if the court makes written findings based on the record that all of this is meant. What does the record mean? Well, if it means the record at the time the court's injunction was entered, then what that would mean is that court orders across the country are going to be set aside, at least consent decrees. Because when consent decrees are entered into, there's not this kind of finding by the court. In fact, correctional officials typically, they refuse to enter into a consent decree unless there's some kind of provision in the decree that says just by entering into this decree does not mean that we're violating the Constitution. So if that's what record meant, court orders across the country would be immediately set aside. But the alternative interpretation is that record, based on the record, refers to evidence that's been adduced and presented at a hearing. So the question is, does there have to be a hearing to determine whether or not the prospective relief is still needed and is narrowly drawn, et cetera? Some of the circuits are saying that there is a right to such a hearing, and for example, one of the courts mentioned, how would we possibly know whether or not the violation is current ongoing unless we have such a hearing? One part of the termination provisions that really has not become the focus of litigation yet, I think we're in the first round of PLRA litigation, but something that's going to come up, I think, is this. Under the PLRA, if the court denies the termination motion, because it finds that this exception applies, under the PLRA, the prison officials have to wait a year, but then they can come back in again with another motion to terminate. And what that means as a practical matter is this. If we're going to have a hearing each time there's such a motion, there's going to be really ongoing litigation. Basically, each year, the court will be re-examining whether or not there's a constitutional violation, whether or not the relief is narrowly tailored, etc. Now, there's been a lot of litigation regarding the constitutionality of the termination provision. And one of the questions about that's come up, one of the constitutional issues is, does it impinge upon or does it violate separation of powers? And again, there are a lot of different arguments that have been asserted by prison advocates as to why they believe it impinges upon separation of powers. But one of the issues is this: does the termination provision unconstitutionally reopen a final judgment? There's a Supreme Court case, Plout versus Spendthrift Farm, Inc. And what had happened, kind of the history leading up to that case, the Supreme Court had interpreted a statute of limitations dealing with securities litigation. And the court had interpreted this statute of limitations in such a way that it led to the dismissal of a plaintiff's case. Congress disagreed with the way in which the court had interpreted the statute of limitations. So Congress passed a statute clarifying what it believed had always been the statute of limitations and directing the courts to reopen all those cases that had been dismissed because of limitations problems. So now the case or issue comes before the Supreme Court. Does this congressional statute directing courts to now reopen those cases, does that statute impinge on separation of powers? And the court concluded that it did, that Congress was unconstitutionally requiring the courts to reopen a final judgment. So the issue concerning the PLRA and the termination provision is, does the termination provision unconstitutionally require the federal courts or federal court to reopen a final judgment? The circuits thus far that have addressed this issue have distinguished Plout, but they've distinguished it for different reasons. Once again, we have a difference in reasoning, because of the difference in reasoning on this and the three strikes issue, I do wish that the issues could get to the Supreme Court so we could get some helpful clarification. But two of the circuits, the 4th and 11th circuits, have said, now wait a second, this is different with the PLRA, because we're talking about having the courts re-examine an injunction. And that's different, because in Plout, the case involved damages only. And these two circuits have said an injunction is not a final judgment. And the reason why it's not a final judgment, according to these courts, they say these injunctions, sometimes they last, it seems like forever. They're 20, 25 years, 30 years, and they change over time. They can change over time. So they are not a final judgment. Now, if that reasoning is correct, it may be, it may not, but if it is correct, what that means is that a bill that's passed the House twice now is constitutional as far as this separation of powers issue. This is called the delay amendment. Again, it was passed last year by the House, and it was also passed in June again, and is now in the Senate. And basically, what this bill would do is set aside any consent decree that was in effect at the time the PLRA was enacted, period. In other words, the delay amendment would set aside consent decrees, for example, in the prison area, even if conditions in the prison are still unconstitutional, and even if prison officials want the consent decree to remain in effect. But if those circuits are correct that an injunction is not a final judgment, then this is okay, as far as that part of the Constitution is concerned. So this is a piece of legislation that you might want to keep an eye out for, because this may be something that you're going to confront down the road. Now, there
is the RUFO problem.
Well, there's the comment that there is the RUFO problem. Now, if what you refer to as the RUFO problem is that in a Supreme Court case called RUFO versus Inmates of Suffolk County, the court said there that a consent decree, I don't have the exact language here, but basically said that a consent decree is a final judgment, period. But what the 4th and 11th circuits have responded, they've said, well, it's a final judgment for some purposes, but not for other purposes. And for separation of powers purposes, it is not a final judgment.
As to prospective relief.
Yes, yes. Some of the other circuits that have upheld the termination provision, these circuits have held, well, an injunction or prospective relief, that it is a final judgment, but that it can be modified to the extent equity requires. And because of this change in the law due to the PLRA, because of the termination provision, equity requires that courts re-examine these orders that they have previously entered.
View that these are private rights in these consent decrees that are entered into between inmates and a Department of Corrections. If the rights are considered to be, these federal rights are considered private rights, then clearly the Wheeling, West Virginia case, which dealt with public rights and allowed a consent decree to be set aside, would not apply. I wonder what the holdings that are coming down in this area will do to consent judgments generally.
Well, all right, a couple points. First of all, there was a mention by the judge of there is another separation of powers issue raised. In fact, there are several others raised by the termination provision. And one is whether, that brings up the Wheeling issue, is whether or not the Congress is basically dictating the result in a case without changing the underlying law. And the response of the circuits that have found that there is not that kind of separation of powers problem, they're saying, well, Congress has changed the underlying law. They've just changed the court's remedial authority. And they've also said that Congress isn't dictating a result because the courts must still go through this process of deciding whether or not the relief is still necessary to remedy the violation, etc. Now, what you have brought up is that there is language in the Wheeling case that seems to suggest that generally setting aside even the prospective relief would create separation of powers problem. There it didn't because it dealt with a public right. But with a private right, it would. So again,
clearly, if that proposed legislation to which you referred a moment ago in the House were to become law, there'd be an effective argument, it seems to me, for separation of powers application.
Well, I think one of the values of this amendment is it does help to crystallize the constitutional issues.
The purpose of declaring it unconstitutional?
I'm sorry, in terms of, for example, determining whether prospective relief is a final judgment, and also whether this argument that it is a final judgment, but it can be the judgment can be re-examined to the extent equity requires, and equity requires it because of the change in the law. Well, this would be a change in the law.
In the Sixth Circuit, they attempt to get around that by saying, but that question always remains with the judiciary, so that if that legislation to which you made reference, I forget what the House bill number is, were to become law, it seems to me it would be a slam dunk for a separation of powers decision.
So one of the questions or points that's been made by the judge is, is where are we going from here, not just in terms of legislation, but what are the implications of the termination provisions? And right now, the law is terminating consent decrees and court orders in the prison area, subject to this caveat. And the reality is, if this is constitutional, then we could have similar legislation in any other area of the law. So it is.
There's yet another level of problem, which is the consent decrees have a contractual component to them. And the question is whether or not Congress can, consistent with the Constitution, impair the contractual agreement made by the litigant.
Right. So the judge's point is that beyond the separation of powers issue, there are some complicated due process issues as well. Do the inmates have a vested right in this consent decree to which they've contracted, and does now requiring them to basically reprove their case and maybe even every year unconstitutionally impinge on that constitutional right. Now, I had mentioned that there were two restrictions in terms of the remedial relief awarded to inmates, and the other area where we see restrictions is in the attorney's fees. There are a number of restrictions on attorney's fees that can be awarded prisoners in these kinds of cases when they prevail. And I think the two that are the most important or the most significant would be number 3 and number 4. Basically, what the restriction referred to in number 3 is that the defendant can be required to pay only attorney's fees that would be 150% of the monetary judgment. So if the inmate receives $100 in damages, the most attorney's fees that the defendant can be required to pay would be $150. And again, you've had a lot of prisoner cases, I imagine, in your court. You may not have had a lot go to trial, but you do know that very often if they do win, they often won't win big. The monetary relief will often be small. So this can have a dramatic effect on the attorney's fees that are awarded. And then also there are restrictions on the maximum hourly rate that can be awarded for attorney's fees. The bottom line is this, is that when you do all the math, the most that could be awarded in attorney's fees, at least in some districts in the country, would be $112.50. The Judicial Conference has authorized in 93 of the 94 districts $75 an hour for work under the Criminal Justice Act, and that's kind of the guiding light for the award of attorney's fees under the PLRA. But here's the catch. Congress hasn't appropriated funds to actually implement this kind of award across the country. So Congress has only appropriated funds to permit attorneys under the CJA to receive $65 for in-court work and $45 for out-of-court work. So what that means as a practical matter is that in many districts are looking at the appropriated funds, and they're saying that attorneys representing these prisoners at most can get $97.50 for their in-court work and $67.50 for out-of-court work. For some attorneys, that would be a significant reduction in what they would typically have been awarded. I did want to tell you briefly about the impact of the PLRA. The question is, you know, we've seen all of these restrictions, and as a practical matter, what has that meant to the courts? And before the PLRA was enacted, the number of prisoner suits filed was increasing dramatically. Between 1980 and 1995, the number of suits went up 227%, but during that same time period, the number of state prisoners went up 237%. So the per capita rate was actually declining. But the point is, the number of civil rights suits was going up enormously. Now, let's look and see what's happened with the PLRA. I've got the pre-PLRA figure. This was the number filed in 1995 by state prisoners. 1998, by 1998, we've seen a 37% decrease in the number of civil rights suits filed by state prisoners. And what's a bit remarkable about that, or striking about that statistic, is that at the same time the number of state prisoners has gone up 13%.
Is that both state and federal courts?
No, this is just federal court, the federal district. It's just federal.
But in Michigan, state prison claims are going up.
Yes, okay, and again, so we may have this dramatic reduction in the federal courts, but we're now seeing many more lawsuits filed in state courts. Now, in some states, though, they are parroting the PLRA. They're adopting their own versions of the state PLRA, so it may be over time that will spread across the country. It has been my pleasure and honor to talk to you today about the Prison Litigation Reform Act. I hope you enjoy the rest of your stay in Baltimore. And again, I encourage you to come up here and talk with me after the session. Thank you very much.